Matter of LLC 410 East 78th Street versus DHCR.
May it please the court, Nati Winiarski for the appellant from the law firm of Cook & Marino, Winiarski and Bittens. I'd like to reserve 3 minutes for rebuttal, Your Honor.
Yes.
So, permit me to illustrate the following. Imagine, if you will, a landlord buys a building in 2025, and in the course of furthering his due diligence, he notices that 4 years ago, there was a rent increase in a certain apartment, went from $1,000 to $1,500, based upon $100,000 in major capital improvements. And in the course of his due diligence, he sees there's no documentation supporting that. And therefore, he says there's only documentation supporting $80,000, and therefore the rent shouldn't be $1,500, it should be $1,400. And he seeks to correct it, to correct the record to lower the rent. Under the DHCR's interpretation, there is no mechanism to accurately reflect that amendment.
So why isn't DCHR free to do that? Why can't they put whatever restrictions they want on the regulation? I mean, the regulation says, there's a phrase in there, propriety of such amendment. Why doesn't that give DHCR the discretion to determine what amendments are proper, regardless of your hypothetical?
They absolutely should. And it's my position that they never provided an opportunity to present the propriety of the amendment. In fact, if you look what happened here,
Who's the they that you're talking about?
the DHCR. Specifically, this application was made in July 16th of 2019. Within 2 weeks, DHCR rejected the application. Now, to the extent that we have experience with DHCR, we know they generally take months, if not years, in
Do
rendering
you
it.
agree that DHCR could amend the regulation to provide that it would not allow for amendments other than ministerial ones if it did so explicitly?
Yes, and they would have to go through SAPR to do that, which they didn't do, which
I understand, but to the extent that they chose to do so explicitly, you're not suggesting there's any barrier to that?
No, I am not. I'm trying simply to read the statute as it exists. As Your Honor said, Justice Singh, is what they're supposed to do. And in fact, if you look at the PAR decision, which is rather interesting, and the reason I raised the claim of the IAIs, which is different than our particular instance, is because I want to demonstrate that this impacts so many units, and specifically in relation to the RA order.
Can I just ask you how it impacts so many units? What is the impact of this? Because my real question is, what's the harm in what they did? Couldn't you file a future registration that accurately reflects what the correct rent is?
The answer to that is no. And in fact, if we could have, I wouldn't be here. We wouldn't have spent tens of thousands, hundreds of thousands of dollars and years in litigation if we could. And the reason you can't,
What
Your Honor,
stops
the
you?
reason you can't, if you look at the registrations, in fact, if you look at, on the record, it's 117 of the record, you actually see the registrations. You can only go back 1 year. And therefore, in my example, when we filed the application in 2019, you could not correct something that happened in 2016 and 2017. And what needs to be also understood is that registrations are filed on a computer, and you can only allow what the fields allow you, and it doesn't let you go back more than 1 year. And so you're not getting an accurate representation of the registration. And I think when we were, the Court of Appeal, Your Honor's had argument in front of Burroughs 2 days ago, and I think it was generally concluded, and I believe you said, Justice Rivera, that it's important that we get accurate numbers. And this doesn't allow for accurate numbers. And to go back to Justice Halligan, what you said, this was amended, right? From 1984, when registrations were first filed, for 30 years until 2014, in fact, they say so in their statutory, in their explanatory statement. They say, DHCR has allowed owners to file amended registrations at any
Do you
time.
know if, maybe this is a question for your adversary, but do you know if prior to the amendment in 2014, the type of amendment that you're seeking to file here could have been filed unilaterally?
It was absolutely could have been filed. And what they sought to do, and it's perfectly understandable, they said, look, we're receiving thousands of applications at this time. It's too much for the DHCR, and it also possibly corrupts the system because landlords can unilaterally file it without any explanation, without seeking to justify it. And so therefore, they say in the explanatory statement, we're going to still allow for such amendments. We're going to still allow you to amend for any time, for any reason, for any purpose, but we want to ensure that the process is regulated by us, which means you're going to need to establish the propriety of the registration, which is fine. And they say something else which is really relevant to the appellate division decision, and they say, we also want the tenants to comment on it, right? And the reason I'll raise that is as follows. Going to the PAR decision, in the PAR decision, the DHCR says,
I'm not clear why they just, it's their own reg, why they can't interpret that.
because
For
it's,
for the purposes you've identified now, because they're overburdened, they're concerned about the corruption of these registrations and so forth, that they're only, and you've given me a one-year look back, so during this one-year look back, with respect to something that is not ministerial,
they can,
doesn't it incentivize landlords to get it right?
well, look, let me answer your first question and the second
Yeah,
question.
Yeah,
They cannot choose to ignore the statute which they amended. And the statute which they amended, the way they
they
did
can't
it,
amend a statute.
they can change the rent stabilization code. They write the rent
The
stabilization code.
regulations, they can't
Right,
amend the statute,
Right,
that's the
they
legislature.
can amend the regulation, as Justice Halligan said, if they wanted to do it limited to ministerial, they can go ahead and do that. But as it's written, they can't just ignore the statute. And the statute, specifically in the explanatory statement, said, we're going to continue to allow you to do this. Now, the next question you ask is, well, why doesn't the landlord just get it right? Which really brings me to the appellate division decision, because in the appellate division decision, they say, DHCR notes that oversees nearly 1 million apartments to rent stabilization, which means there's 1 million rent regulatory statements that are filed each year, which also means that with 1 million applications being filed, inevitably, there's going to be mistakes, right? And when I raised this originally, that example I raised, they said in their RA order that we're not going to consider individual apartment improvements, major capital improvements, vacancy guideline increases, renewal increases. We're not doing any of that. We're limiting it only to ministerial items, which is not only in conflict with the statute and the way they explain the statute, but more to the point, when you look at the PAR in which they
No,
affirm.
Can we go to where you see the conflict of that? Because I don't see what is arbitrary about the agency saying we're only going to look at ministerial ones and anything else are too time-consuming. And we've made a decision that there are some amendments that lead to fraud more than others, and we're going to make this ministerial or administrative difference. That's how we're going to
So-
comb through the thousands of these. I don't see that as being arbitrary or irrational.
It's arbitrary to the extent that when they put this statute in place, they said in their explanatory statement, we are going to continue to allow you to file amended registrations at any time for any year, and then they enact the statute, which simply says, all you have to do is establish the propriety of the registration. They do not say, so what they're saying in saying that is, we're going to take a substantive look at the application and determine if you've established a propriety. They don't say here, they could have, but they don't, saying, and such registrations or amendments are limited to ministerial in nature also, only. And if they were to take
And that doesn't fall under the purview of their right, ability to interpret their regulations as they like?
I understand that this court generally gives deference to the state agency in relation to their interpretation of regulations. But
Their
not-
own regulation.
Their own
We're
regulation.
not even talking about a statute here. We're
But
talking
not
about
when
their
it's
code.
not consistent with the words of the regulation which they enacted. And you look at this, and all it says is, establish the propriety of the registrations, which is consistent with what we've always done, but now we just want to have oversight over this. Which brings me again to the PAR decision, and in the PAR decision, what the agency said is, in reviewing an amendment application, the rent administrator is tasked with determining whether sufficient justification has been provided. So they say, What we're going to do is we're going to look as to whether you provided sufficient justification. In other words, they're looking at the merits of the application. They say,
Is this the 2018 Rosenberg that you're referring to?
no, this is our case, but you're correct. In Rosenberg, they did exactly this.
You mean the
and-
par here?
In the par
So
here.
what has the practice been, if you know, since 2014 to now? You pointed us, I think, to Rosenberg, which is one case in the last 10 years. What has DHCR done, and I'm sure they'll be able to respond to this as well, but with respect to substantive amendments as opposed to ministerial?
I can't tell you how many applications have been filed. What we know is this. What we know in the explanatory statements, they say there were thousands of amended applications being filed before 2014, and we want to limit that, and we want to have.
Right, but in your experience, I mean, and maybe the answer is you
It's very
you
limited.
can't say. Okay,
It's
thank you.
very limited. But, you know, you raised the Rosenberg case. In Rosenberg, they considered something that was substantive. Specifically, the facts were almost exactly the same, which was you had a free market unit in which they filed, by mistake, a temporary exemption, and they considered it. Now, what they say in this case is, well, in Rosenberg, you provided us copies of leases, and here you didn't provide the justification for that. But that's not.
Counsel, can I ask you something practically? So let's say the same facts here. Say it's temporarily, not registered. Tenant comes in and sues and says, you had a filing that said this was temporarily not subject to regulation, and then you took it out again, and it is out because it had been deregulated. But based on this erroneous filing, a tenant now brings an action against you. What happens?
I think it leads to a perception that there was a possible fraud committed, which is why exactly the landlord in this case brought this application when it did. Keep in mind, the HESPA, the Housing Stability Tenant Protection Act, was enacted in June of 2019. It's within a month that my client brings this case because HESPA imposes penalties if you don't get your registrations right. And I don't see how we can impose penalties for not having proper registrations.
Well, I guess it could say, well, you get a penalty if you don't correct it within a year, but what would happen in the lawsuit? Tenants bring an overcharge claim saying this apartment should be regulated. It was temporarily unregulated, and then you put it back on, and it should have been regulated.
I think it certainly leads to a possible inference of fraud, despite the fact that none existed. And specifically, the reason for that is, in 2002, you have a registration which says this apartment is deregulated as a result of high rent vacancies. No registrations are filed from 2003 to 2015. All of a sudden, you have 2016, you have, it's temporarily exempt, meaning it should be regulated. And so now a tenant comes in and says, something doesn't smell right here. And mind you, the Supreme Court determined that it's undisputed these registrations were filed mistakenly. Which brings me back to my original point
So
of,
why wouldn't that be enough, in response to Judge Garcia's question, to address a claim should a tenant bring one?
look, so if Supreme Court in this case said it was filed mistakenly, it doesn't necessarily bar a future tenant for saying it wasn't, that wasn't the case. But I also don't want to limit it to this specific case. This case impacts thousands of possible registrations.
So is it the uncertainty that you...
Yes, I think it goes to the accuracy of the registrations and our want to get accurate registrations on file, which is all we're seeking to do in this instance.
If you were allowed to do this, hypothetically, would there be a record of the correction?
Yes. I see my time is up, and I reserved a few minutes for rebuttal.
Thank you.
May it please the Court, I'm Robert M. Barris. I'm of counsel to Mark F. Palomino, who's the counsel for the respondent, New York State Division of Housing and Community Renewal.
Does the regulation facially restrict amendments to ministerial and clerical errors?
No, it does not facially restrict it. Our position is that the agency's practical determination to to restrict the scope of allowed registration amendments to clerical and ministerial errors, which is the term that was used in the administrative determination, is a rational exercise of the agency's discretion in the administration of the rent registration
So
system.
could, I take it, you think, amend the regulation to say that explicitly, yes?
Absolutely, yes.
And so we've held, and I think visiting nurses service is one case, but there are others that the agency gets a lot of deference when it's construing its own regulations, but that it can't adopt a construction of a regulation that doesn't conform with the plain language of the regulation. So I think it's clear there's not a distinction between ministerial and substantive in the regulation. How can we read it that way?
It's not really a question of reading. It's a question of the exercise of administrative discretion, which several members of the panel have touched on here.
But you still have to exercise your discretion, I think, in a manner that is consistent with the language of the regulation, right? So, for example, if the regulation said you may only file ministerial amendments and not substantive ones, I am going to guess you would say that you would lack the discretion to take a substantive amendment. Is that fair?
That's correct.
Okay. And so I'm just looking at the regulation, not seeing any distinction of the sort that you're trying to make here, and I'm trying to understand how we can see that as a fair reading of the language of the regulation itself.
My response would be that the DHCR's practice is a rational exercise of the discretion afforded to it in the administration of the registration
Do you know
system.
if before 2014, when the reg was adopted, and there were unilateral amendments, as I understand it, could an amendment of the sort we have at issue here have been filed unilaterally before this regulation was adopted?
Yes.
And so what here supports that the interpretation is in fact rational?
In the explicit text of the regulation, you're correct, Your Honor. There is no explicit support for it. Our argument, which we've made in our brief, is that the way that the rent registration system is structured, the way it functions, is as a historical record over the decades of contemporaneous representations by landlords as to the regulatory status, legal rent, and occupancy, and other information about their apartments, and those representations are just that. They are representations. They're unilateral. They're unverified. The agency does not have the resources to check on the accuracy of.
Can I, just to be clear, because it appears I think you've answered Judge Chapman's questions. If not, she'll correct me and ask you something else. Since its enactment, DHCR has always interpreted the regulation in the way it has here, correct?
I believe so, Your Honor.
So this is not a case where there has been varying interpretations of the language by
As far as I know,
DHCR.
Your Honor, this is not an aberration.
Okay. And if I'm understanding, I think perhaps the argument in the briefing and perhaps what you're suggesting today, DHCR, when it enacted this, intended it to be interpreted in this way? Or is that an interpretation that's evolved over time?
I don't have a specific answer for that, Your Honor.
Okay, thank you.
Counsel, my hypothetical before, what would happen in the case of the tenant comes in and says, you said this was temporary and now?
Right. The landlords are not powerless to protect themselves against such future.
Well, now if we rule for you in this case, hypothetically, they wouldn't be able to even say, well, I tried to amend it, right? Because we're going to say, don't bother.
That's correct. That's correct. They could say, we tried to amend it. They have a record of that.
But now they won't, because we'll say, you don't have to take that. So what would they say?
Well, my answer to that would be that they can take protective measures to.
What would those be?
Pardon?
Yes, such as what?
Such as preserving documentary evidence.
But let's say they discover this years after the look-back period is over. They don't have the records.
Well, if they don't have the records, that's a problem. But they can also, one of the arguments that the appellant makes in its briefs is that if a challenge did not occur for years or decades, witnesses might no longer be available. Well, they can take affidavits of witnesses while they are still available and use them in the future. There's also something else they could do is when a future tenant takes occupancy, they can preemptively advise the tenant that there is this seeming inconsistency in the registration, and this is the explanation, and support that with documentary evidence, and thereby preempt what the kind of litigation that they're concerned about.
Why isn't the request here ministerial? Over here, straight ahead of you.
Pardon?
Why isn't the request ministerial here?
Why is the
Request, they're asking for something, why isn't that ministerial? They're saying we made a mistake.
because it pertains to one of the three core elements of a registration, which is regulatory status, legal regulated rent, and occupancy.
So if they
and
had,
that's why it's
so
not.
if they had mistakenly listed the rent, let's say, as they've added an extra zero.
That we would take. That would be clerical or ministerial.
Well, but that might affect the rent regulatory status. It might fit into one of your first three categories you just gave me, right? So I'm trying to decide whether you're defining ministerial based on somebody at a typewriter hit an extra key and that was a ministerial error, or however they made it, substantively it fits into one of the three categories and therefore we're calling it not ministerial. And I don't perceive a consistent answer from you so far.
I think that my answer would have to be, Your Honor, that determination would be made on a case-by-case basis.
Well, wouldn't you have to look at the entire rental history from 2002 to make a determination if it was legally deregulated? And what does that entail versus changing the rent amount?
Could you?
Like, in order for you to figure out if the amendment was proper, you would have to look back at the entire rental history since 2002 to make the determination that when it was deregulated.
That would be a substantive determination.
So
and
is that your?
That would inherently go beyond the clerical or ministerial category.
And would that have to happen here?
In what case?
In the case that's before us?
Right. Would that have to happen in the context of a registration amendment?
Yes. If he's saying it's not, it really is deregulated, so we'd like to correct that, don't you have to go back and make a determination?
Of course, you have to. Of course, you have to go back and look at the
two. Is that a little bit of work, or is that a lot of work? I'm trying to understand why it's not ministerial.
All I can say, Your Honor, is that we were discussing this yesterday with counsel and deputy counsel and supervising attorneys, and our position is that anything that affects one of those three core characteristics of an apartment is by definition, unless it's a matter of a decimal point or something like that.
How do you explain Rosenberg?
Okay, in Rosenberg.
How many more cases like that are there?
I don't know, but the distinction in Rosenberg, which we made in our brief, is that in that case, the landlord came forward with three leases, and it was in the context of an adversarial proceeding where the tenant was involved and had notice and an opportunity to respond.
Does that sound ministerial to you? An adversary proceeding with a tenant and leases?
Well, one of our rationales that we put forward in our brief for not entertaining this kind of application is that there is not a real tenant in interest who would be given notice and an opportunity to be heard and have an incentive to investigate the apparent inconsistency. And
Yeah,
in
but
Rosenberg,
right, but again, that makes it seem even less ministerial, because now you have an adverse proceeding. I mean, what you're telling the landlord here is that what they should do is kick the super out, put a tenant in, and then refile, and then you would consider it. That sounds nothing like ministerial. And I feel sorry for the super if that happened.
pardon?
I would feel sorry for the super if they had to do that to get the relief they want.
My answer to all these questions would be that it is hard to draw a bright line distinction.
Well, sounds like a pretty bright line distinction to say it's either on the ministerial side or the substantive side. And I think the questions are to get a sense of how that line has been drawn. But yeah, I just want to be clear, the hypothetical he started with, is it DHCR's position that that can never be amended? Or if there was a new tenant and they wanted to raise it, they could raise it? Is that, I'm just trying to understand what DHCR says might be the only way they could address this problem.
Right, in the event of a tenant challenge.
So whenever a tenant challenges, you're going to review it?
Well, the
That's
distinction
perhaps
is
a bright line
that,
in the sand. If a tenant challenges it, you're going to review it, and you'll give the landlord the opportunity to make their case.
well, certain kinds of determinations are mandatory, and among those are overcharge applications by tenants. And in case there was such a challenge, an overcharge challenge and/or a status challenge, the agency would be mandated to adjudicate and determine that.
So you say in your brief that one of your concerns and the reasons for your construction of the regulation is how your investigative and auditing resources are allocated. So if we were to disagree with you, is there anything that would stop DHCR from promulgating a regulation that more precisely comported with its priorities, understanding that if you had to go through SAP or whatever those procedural requirements would be?
Absolutely not, Your Honor. The agency could promulgate such an amendment.
And I assume would have some leeway as long as you were within the statute to allocate your resources as you chose. I mean the RSL, not the RSC. To promulgate a regulation that allowed you to allocate those resources as you wanted.
Correct. If the panel has no further questions, I'll rest, and thank you.
Thank you.
So,
Can I just ask you about Rosenberg, please, because it's come up? So the way I see Rosenberg is there was an amendment based on the fact that the owner didn't live in the apartment, and basically all they did was provide a lease of a tenant to demonstrate that the owner didn't live in the apartment. So to me, that sounds pretty ministerial, as opposed to here, where we'd have to go back to 2002 and recreate the rental history to make a determination if the deregulation was proper in the first instance.
So
Why am I wrong about that?
respectfully, the facts in Rosenberg are exactly like this case because it was a free market, it was a deregulated unit, as in this case. They filed a temporary exemption based upon owner occupancy. The distinction that he told you, which is, by the way, contrary to Justice Rivera's question when she asked him, did you ever issue a decision like this? And his answer was no, but Rosenberg clearly indicates otherwise. So the distinction that they raise in Rosenberg is that, well, you offered leases. We offered leases in that case, and there was a current tenant in possession. And that's a distinguishing factor, which I can abide by. And they say in their brief that our reliance on the registrations to contradict another without proffering substantive evidence indicates the rationality of their decision. The problem with that is they never reached a substantive determination in this case. Within 2 weeks of the filing, they
Right,
just said.
but why isn't it within their discretion to say, we're not going to put in the legwork where we have 5,000, 10,000 of these coming in, because we know we have to go back to 2002 and make a determination about deregulation, which is not easy, and we're saying that that is substantive, and we've made a decision that unless it's ministerial, we're not going to allow these amendments. And that might be in response to the flood of amendments that they've gotten. Whatever their reasoning is, why isn't it rational for them to say, look, we're not going to spend the man-hours that we need to figure this out because it's going to take us away from all the other amendments that we're getting?
Because they only provide one mechanism, 2528.3C, which says, here is how you amend it. And we heard a very important admission from my adversary in response to Justice Halligan's question, which is, did you previously allow such amendments before 2014? And his answer was yes.
Yes,
And
I mean,
the-
that's a given, but are they not free to change their regulations in response to circumstances?
They are absolutely free to do so. But when they instituted these regulations and they provided the explanatory statements, they said, we will still allow you to make these type of registrations, provided we have oversight. And that's where and again, if they wanted to implement a different rule, they
But
have
aren't they
that.
still allowing them if they're ministerial?
Excuse me?
Aren't they still allowing them if they are ministerial?
They're still allowing what?
The amendment.
They're only allowing ministerial amendments. They're not allowing substantive amendments. And when you read the
But
regulations.
isn't that consistent with their policy from the time it went into effect, post?
2014? No. Because
2014?
we know in Rosenberg, that was a substantive determination. That was a determination as to status, which is exactly why they rejected it here. So,
Let's
you
say
know,
we don't view Rosenberg the way you do. Why is it that this is not wholly appropriate for them, given the concern that you yourself identified as to why you have this amendment, that they are trying to reduce the number of registrations that they have to deal with?
they are trying
That's the
to,
intent behind it. And
Understood.
their interpretation is the one that they've
and I don't think there's any question that it has been reduced. And that's why we don't see a lot of these cases, and which is why I couldn't answer Justice Halligan's question of how many are there. There's been a tremendous reduction. But while we have the reduction, and while we're seeking to make sure that we have an accurate registration history and maintain the integrity of this, my suggestion for this case is what the appellate division intended, which is remand this case back to DHCR. There's a tenant in possession now who can participate in the process and decide it. And I think that's what needs to happen. When that was clearly the
I'm a
intention.
little unclear now. Why can't the tenant just file some claim? I'm a little confused now.
The tenant can file a claim, but it hasn't. And what we're looking to do is make sure that we have an accurate history. So allow this case to be remanded back to DHCR to the extent the tenant wants to participate. It can. Notice should be sent to the tenant to invite it to participate in the process, and then make that substantive determination as to whether the registration history was erroneously filed or not erroneously filed, and allow for the maintaining of the integrity of the system, which seeks to ensure.
Let me ask you this. If there's some legal doctrine that would prohibit us from saying, it is obvious, given the articulation of the purpose of the 2014 reg, that they are trying to reduce the caseload, they're trying to limit this in a particular way, and they always intended for it to be interpreted in the way they have now articulated their interpretation. Is there any legal doctrine that bars us from resolving the case in that way?
Yes, and
Okay, go ahead.
as Justice Halligan raised matter of visiting nurse services, 5 NY 3rd 499, courts are not to embrace a regulatory construction that conflicts with the plain meaning of the language, and similarly, Curse 6 versus Merchants Mutual, 49 New York 2nd, 451, where this court said, where the question is one is pure statutory reading, which is all this is, especially in light of what just happened since.
I'm saying, I'm not, one would have to agree there's a conflict or inconsistency. That's, you got to start there.
If it's running counter to the clear wording of the provisions, and they're putting in, and as he's answered your question, is this evolving? And he said, yes, it's evolving, meaning we don't have a clear policy here. And what they did instead is they implemented a regulation which says, we're going to continue to allow for all of these regulations, provided we have oversight. And then they implement a rule saying, no, only ministerial sometimes. Well, then you have that conflict.
Thank you.
Thank you.